Hello and welcome to our webcast for September 29, 2017. My name is Christian Debré and this is Amy Hasbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
And we are welcoming to Taylor Hyatt, sorry, my memory is not so good, Taylor Hyatt, who will help us in our task. Toujours Vivant, Not Dead Yet is a non-religious organization by and for people with disabilities and our allies. Our goal is inform, unify, and give voice to the disability rights opposition to assisted suicide and euthanasia and other ending of life practices that discriminates against people with disabilities. Today's topics: review of Canada disability rights legislation, the Ontario part. The second subject will be second plaintiff in land case died by euthanasia. So Amy has worked with ELPA, will help us with those two subjects.
Okay. We'll start with a review of Canadian disability rights legislation in Ontario. This is the second part of our series on Canadian disability rights legislation. Today we're discussing a law in Ontario known as the Accessibility for Ontarians with Disabilities Act, or AODA. The AODA was passed in 2005. It's very similar to the federal proposal, and here's a list of what it covers. The AODA covers the activities of provincial and local governments, nonprofit social services, and private businesses. So it's pretty comprehensive.
Yes, but those things doesn't talk very well together normally.
Right, exactly. And, you know, especially trying to get provincial and local governments to talk to each other, that can be pretty tough. And get them to cooperate together, it can be pretty tough. Like the proposed federal legislation, the AODA discusses accessibility in hiring and recruiting procedures, as well as accommodating employees who return to work after acquiring a disability. Individual accommodation plans for employers, plans for emergency situations like evacuations, and reassignment of someone's position within a company, i.e. if the disability status changes, are only mentioned at the provincial level. So some practices in employment are covered at the federal and provincial levels, and some practices are only covered at the provincial levels. And those last three, reassignment, evacuation, and emergency situations and individual accommodation plans, are only covered at the provincial level.
It's mainly due to our politics way to do that in Canada. That's responsibility are different from federal than provincial.
Right, right.
At both levels have different responsibility. So for some subjects, sometimes it does go one over the other, which is very difficult.
Right. Transit regulations describe accessibility measures for local transit and intercity buses, streetcars, subways, light rail trains, and taxis within towns and cities. Accommodations include lifts, announced stops, and priority seats. Fares, hours of operation, and eligibility standards for paratransit are also covered. So when you have a public transit system, you need to have a system aside from that that can be used by people who can't use the public transit service for whatever reason. And oftentimes they can't use the public transit service because it's not accessible.
Yeah.
So the goal is to make the public transit service as accessible as possible so that the most possible people can use it. But they haven't been, that isn't how transit systems have been operating. They've been mostly saying, well, we'll just have this paratransit service for disabled people. But the only problem is you have to reserve at least 24 hours in advance. They limit the kind of trips you can take. They say you can only take trips to doctors and to school or work, and they limit whether you can take social trips to visit family or friends, that kind of thing. And Also, sometimes they won't operate like on a Sunday, and obviously people's lives don't stop on Sundays. So the AODA is supposed to include paratransit regulations for dealing with all of those issues, but also it's supposed to create access to the mainline public transit. Okay, access to buildings is managed through the AODA and the Ontario Building Code. The AODA primarily covers new buildings and major renovations in public and private spaces. The code is enforced locally by municipalities through building permits. It specifies the following accessibility features as of 2015, and that includes barrier-free common areas in buildings, elevators, visual fire and smoke alarms, accessible washrooms, accessible pools or spas, and visitability of apartments. And the apartments have to be barrier-free access to bathrooms, bedrooms, kitchens, and living rooms. So another thing I noted when I was looking at that was that in multi-dwelling apartment buildings, 15% have to be accessible units. So the problem that you run into here is that building inspectors don't necessarily understand why access regulations are the way they are, and so sometimes they won't enforce them.
Yes, and there is trouble with smaller municipalities. Sometimes they have only one employee working part-time, which he couldn't have understand and knows all the law that he has to manage for a municipality.
Well, but that's his job.
Yes, this is his job, but the problem is the way the information transits from one side to the government to the other one,
right,
and the comprehensiveness of these things.
Right.
And this is not done.
Right, and access is given a very low priority.
Yes.
And people don't understand why the rules are the way they are. And so if there's a question, people say, oh, don't worry, do it whatever you want.
When the contractor arrives and say, oh, could I replace a cane knob for a round knob? It opened the door the same way. The guy say, oh, I don't know why. Yeah, you should. But it's not the right way to do it.
Right, exactly. It should be noted that adjustments to existing buildings of any kind are not mandatory. Houses, individual homes, are exempt from every standard but the updated fire alarms. So obviously individual dwellings are not covered, and it doesn't say how many units have to be in a dwelling for it to be covered under the law, and I didn't see that anywhere. In the United States, I believe it's 6 units. If there's 6 or more units, then there has to be 1 accessible unit. The rules for public spaces talk about accessibility and on outdoor trails, beaches, playgrounds, equipment, and picnic areas. Infrastructure like crosswalks, sidewalks, and accessible parking fall into this category as well. So the AODA does deal with external infrastructure, getting around town, and using public spaces. Okay, the standard for access to goods and services includes adapting store counter heights and sections of waiting rooms, seating for mobility devices. There are also guidelines for serving customers who use service animals or personal support staff. I don't know if the rules include having an accessible changing room, if in a store. I don't know if the building code is that detailed. The one in the U.S. certainly is. So that's.
What would the difference be between a changing room and an accessible washroom?
If you're in a department store and you want to try on some clothes, you'll have a changing room that doesn't have a toilet in it. Changing room to try on the clothes, and they're usually about the size of a toilet stall. So obviously
Right.
you have to have a bigger one to be accessible to a wheelchair user.
Yeah, with some kind of ramp to.
No,
take
there isn't a stair. Usually it's on the same level.
No, there's something to catch a bar,
Oh,
safety bar.
oh yes, a grab bar.
Yeah.
Yes.
Let's see. The information and communication section covers a lot of ground. Accessible document formats, plus use of captioning, alternative and augmentative communication, plain language, and sign language. All those are covered. New and revamped websites need to comply with the Web Content Accessibility Guidelines. High schools, universities, colleges, and libraries also must offer accessible materials. So that's fairly comprehensive in terms of providing accessible information, but there isn't any information about providing interpreters, for example, for a business like a lawyer. A lawyer wouldn't necessarily, I don't know if lawyers would have to provide an interpreter, for example, in a private office, or a doctor. Those are questions that are open. I don't know if that's true, but it's worth asking those questions.
So it appeared to me that we don't know many detail about this law.
Right.
It's really complicated. The application go to a lot of detail that nobody knows exactly.
Right.
Difficulty to find
Right.
the right answer.
Right. And that's one thing that we noticed in doing research, is that it was hard to find a lot of specific information about the law. Compliance with the AODA is enforced through fines and annual reports about accessibility measures. All organizations covered by the AODA need to file annual reports, including privately owned businesses. Every person, quote, this is in quotes, every person guilty of an offense under the Act can be fined, unquote. So, for violations, and we'll talk about those in a second, the government can fine an organization, whether it's a private business or a public entity. An administrative director appointed by the Deputy Minister for Accessibility is responsible for reviewing annual reports to ensure a group has obeyed the law. The director also sets the collects the fines. There are 3 levels of fines based on whether the violations are minor, like an administrative issue, moderate, a lack of accessibility modifications, or major, a health and safety risk. So if a violation is minor, like that a store hasn't moderated its policy to allow curbside delivery. So for example, if I wanted to go to a store that wasn't accessible and they refused to serve me on the sidewalk, that would be probably a small fine, failure to make an administrative change. Or it could be seen as a medium fine, failure to make accessibility modifications. But since it's not a renovation, then they wouldn't be obliged to make a physical change, but they need to change their policies to make it accessible. And a major health and safety risk would be a situation where their policies would put people at risk. So if they didn't, for example, have visual fire alarms, or if their fire alarms were blinked at such a level that it would cause a seizure in some persons. Okay, projects managed by city councils, including preparation of reports, reviews of renovation and construction plans, and implementation of the Act on city property, should be discussed with local accessibility advisory committee. So they should appoint a committee, and usually it should be people with disabilities, obviously, because they know what accessibility is for. And they need to talk about, the town needs to talk about their plans with the committee. A provincial accessibility standards advisory council has been established by the Minister of Accessibility. The council is responsible for consulting with organizations as they become compliant, creating resources for training and public education, and acting as a link between the provincial government and municipalities. So that is the province's effort to build a bridge between the province and local cities and towns.
Yeah.
And
but this bridge is kind of not really good.
Right. It's, you know, it's this one advisory council, and we don't know what kind of power they have. We don't know what kind of clout they have.
Yeah.
They could just be seen as another advisory group, and the towns might ignore them. It really depends on how much support they have from the administration. Government bodies and businesses with 50 employees or more must create, review, and update multi-year plans for removing barriers. So they have to, not just when they build new buildings or renovate buildings, they have to make a plan for removing barriers. And that's an obligation that government entities have. And I think that's separate from private businesses. These plans must also be made public. Unfortunately, most accessibility policies and plans are not easy to find. A customer needs to ask for them or search online. And I saw a bunch of them online. I didn't really look at the actual policies, but you can find some of them online, but not every town has done them. In fact, the level of compliance with doing these policies is pretty, you know, not great. So if your town hasn't done it, it's not surprising. There is no procedure under the AODA for a person to provide direct feedback to a business or agency they believe has violated the law. So there's no direct redress, as the word is used. I can't go directly to a business and say, you are violating this law.
So it's probably the way that nothing is done, because when you address the government doesn't know exactly what to do with your request,
right,
because it's so big and there's so many people over there, it doesn't know which people to talk to,
right,
and nothing happens.
Right. The person has to file a complaint with the Ontario government, which will contact the business or agency on their behalf.
3 years after, or something like that.
It could take a very long time. The other thing is, I was looking for this information, and I saw two different first of all, at one point they had something that they called a complaint line that you could call, and then it turned out it wasn't a complaint line. And then I saw references to two different agencies that people would have to file complaints to. And I'm thinking, this is 12 years after the law has come into effect, and they can't even get it straight how people are filing complaints. That's not good.
That's a normal reaction of our government in Canada.
No, that's not good.
That's not. I never told that it is good.
That's not good.
It's just normal for them.
Yeah, I have.
And normal doesn't mean good.
I have to say that when I was in the U.S., I was trained in the law and regulations of the Americans with Disabilities Act as part of a government process, and then I went out and did trainings for other people. So I know the ADA very well, and I know what the obligations are. And that was, first of all, making the procedures clear, and then providing training, not just to individuals with disabilities, but also businesses and nonprofit directors.
The whole society.
Yeah, the whole society. It was a priority that they did through the Department of Justice mostly, but through the Equal Employment Opportunity Commission and other government agencies did that. So understanding that Ontario is smaller than the US government, but it's still something to do. Overall, the AODA leaves a lot to be desired. The law does not say much about access and accommodations for people with psychological or intellectual disabilities. And yet again, housing, healthcare, and some recreation and communications technology are left out. So the AODA does a lot of good things. It covers businesses and employment, but it doesn't cover everything, which is pretty true with most disability rights laws.
And we saw that everything that covered are suffering some kind of flaw.
Great. Taylor, did you want to add anything?
Just that friendly reminder not to forget historical exemptions.
Yes. Yeah. Yeah. Yeah, because a lot of buildings, a lot of times they claim that this building is historical property or yada, 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 and it's not really, or they just use that to exempt the whole building rather than, you know, saying you can't touch this building at all, instead of saying, okay, well, the building has to present in a historically accurate way, but we can build a ramp on the back of the building so that people can get in. So they really use that as a way to prevent people from having access.
Mm-hmm.
Okay. Next topic is okay, huh?
Sorry. It's gotten to the point for me where living in a city with so much history, you know the places that you don't even bother going to because they're not going to do anything.
Right, and business owners always say, well, we don't need to become accessible. We don't get any disabled people here.
Yeah.
Well,
I heard it.
Of course you don't get any disabled people here because you're not accessible.
Yeah, there is 3 steps.
Exactly.
And the door is too narrow. Right.
Yeah. Okay, our second topic is the second plaintiff in the Lamb case dies by euthanasia. CBC News reported recently that Robin Moreau, one of 2 plaintiffs in a court case challenging the reasonably foreseeable death requirement of Canada's euthanasia law, received a doctor's help to die at the end of August. Ms. Moreau had Parkinson's disease. She was allergic to many of the pain medications commonly used by those with that condition. Her request for euthanasia was originally denied in March because her doctor did not believe her death was reasonably foreseeable. According to the CBC report, Ms. Moreau's doctor, Ellen Weed, refused to grant euthanasia requests from patients who were believed to have more than 5 years to live, based on statistical projections of the life expectancy of the named plaintiff in the Carter case.
So it's kind of honest from the doctor.
Right. So the named plaintiff in the Carter case, Kay Carter, Dr. Weed said, based on statistical projections, she probably would have lived 5 years. And since the Supreme Court found that her death was reasonably foreseeable, then I'm going to say that anybody who is going to die within the next 5 years, their death is reasonably foreseeable. That's what she did. However, the physician changed her mind following the Ontario Superior Court ruling in June of this year in the case of AB versus Attorney General of Canada. In that decision, Judge Paul Perel stated that the reasonably foreseeable death standard does not require a person's illness to be terminal.
Okay, you doesn't have to be dying to receive the help to die.
Right.
So you could be helped to suicide yourself.
Right. And, there's been some debate about that. And so him putting a judge's stamp of approval on that is pushing it in that direction.
So the boundary that was created with the law doesn't exist anymore.
In a lot of ways.
It's so wide that an elephant could go through the door 12 at a time.
Right, a baby elephant.
Yeah.
Nor does the person's death need to be imminent or likely to occur within a given period of time. So he's saying it there doesn't need to be a specific time period.
If I remember well, 3 or years ago or a little more, we tell that there is a slippery slope and the boundary will not be respected.
Right.
Exactly as the 100 km on the highway.
Right.
Nobody drive that speed except if you have a slow car or something goes wrong.
Right.
You go to 110 or 150.
Right. According to the CBC, Dr. Weed calculated that AB, the subject of the Ontario court ruling, might have lived another 10 years. Thus, this became her new limit. Since she believed Ms. Morrow could not survive that long, Dr. Weed felt Moreau was eligible for euthanasia, that her death was reasonably foreseeable. In the AB case, Judge Perel also said the reasonably foreseeable death applies to a person, quote, who is on a trajectory toward death because he or she, A, has a serious and incurable illness, disease, or disability, B, is in an advanced state of irreversible declining capacity, and C, is enduring physical or psychological suffering that is intolerable and that cannot be relieved under conditions that they consider acceptable. So those are the first 3 criteria of the 4 criteria, the 4th being reasonably foreseeable death. So he's basically saying that if you meet the first 3 eligibility criteria, you also meet the 4th.
Was the result before?
Yeah.
Okay, so the boundary was like that and was widened, and right now the boundary are like that.
Right.
You doesn't see my hand because there is no more boundary.
Right. So his decision could be interpreted to mean that if you satisfy criteria A through B, then your death is reasonably foreseeable and you meet criterion D. So he's not only saying that there's no specific time limit and you don't have to have a terminal disease, but if you meet criteria A through C, then your death is reasonably foreseeable. Even though Ms. Moreau has passed away, she will remain a part of the case, assuming the court allows her husband to stand in for her or relies on Moreau's written statements. The other plaintiff is Julia Lamb, a woman with spinal muscular atrophy living in British Columbia. Although her condition is progressive, it is not terminal. Ms. Lamb is currently able to work part-time and live independently with attendant services. However, she is afraid that a sudden decline in her condition will prevent her from breathing and eating independently and using her hands.
So she's afraid to be afraid.
Right. Well, so, okay, if we take those 4 criteria, she meets number 1 because she has a disability. She meets number 2 if she says she's suffering. Then the question is she in an irreversible state of decline? Irreversible decline
she's in the trajectory.
Well, yeah.
That's the term we use.
If she meets the decline in capability criterion, then she also has, her death is reasonably foreseeable, according to this Judge Perel. And so in some ways, we don't even need to get to the question of whether her death is reasonably foreseeable. We just have to get to the question if her death, if she's in irreversible state of decline. And so this is how the boundaries move.
Yeah. The boundary move from there to there.
This is why the law is so yucky.
Yeah.
Okay. All right. If you want more information about the subjects that we talk about here, you can visit our Facebook page at facebook.com/toujours-vivant, not dead yet. I'm sorry, Taylor, did you want to say something? I interrupted you.
First, you can lose all kinds of capacities and none of those medical conditions can kill you.
Right.
if Ms. Lamb's challenge goes through, how will her condition be looked at by the medical community and parents whose kids also have that condition? Because there's a really fine line and a lot of confusion between disability and terminal illness.
Right, right.
I agree.
And even doctors are often ill-informed about that distinction. And yeah, I mean, if a doctor says, well, no, you're terminal, or, you know, you're in an advanced state of irreversible decline, so your death is reasonably foreseeable.
Yeah.
Yeah. So for more information, you can visit our website at tvndy.ca. You can email us at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christian for helping out.
Thanks
to Taylor also for helping out.
Yeah.
And we'll see you again next time.
Yeah. Thank you.
Bye.
Bye.